Hey everyone, it's Rob Ryder, Tuesday, January 31st, 2012. Continuing on with the Achilles heel of civil law. First, we're going to start with a little out of Lord Coke, Court of Chancery, Chapter 8, Book 4 of his Books of Institutus. Amongst the petitions of the Commons, when they say the Commons, they mean civil law, you shall find this, that all writs of subpoena and certis de causis going out of the Chancery and the Exchequer may be enrolled. Now, the Chancellor is over the Court of Chancery and also over the Court of Exchequer. So just remember that. So going out of Chancery and Exchequer, they're two different courts under the same man. So they may be enrolled and not granted of matters determinable at the common law. So these writs cannot be put out, cannot be granted, if the answer is determinable at common law. So all original writs have to come out from the court, from the Chancellor under his Great Seal. But you can't get one if there is an answer determinable in common law. And so when you look in your civil file, you're not going to find, if you have a civil offense of any kind, I don't care if you went to prison, bankruptcy, foreclosure, anything, it's a civil matter. Go look in the corner, see if it's a civil case. If it is, and in there is not an original writ under the seal, the Great Seal, given out by the Chancellor, then it's because it was a matter that's determinable at the common law, and so they can't get the writ. And therefore, they go under this other avenue they have in civil law. And this was pointed out on number 2, the second video, part 2. So it was actually the third video, but it's part 2 of this series. They get one that's under the seal, under the Privy Seal, under the Court of Records seal, but they have to testify that the value of the case is less than 40 shillings. And so this leads me to think in America of the Constitution, where it says that, for suits less than $20, you don't get a jury. A jury is another thing mentioned in Part 2. So if you don't have a jury sitting there, they're telling you the case is worth less than $20. So I don't care if you got $1 million foreclosure going on. The case itself is only worth $20. Go pay the $20. The case is over, and they can't bring it again. Those are the rules. But that's only one way to do it, and I don't even know if it's the best. But I'm just telling you the way it reads to me. So you would take that case, whatever it is, to the county prosecutor. The guy who was elected to be the prosecutor of the county gets a stipend from the Treasury, so he's already hired for the people. So you just go there with your evidence, and you accept his oath, bind him to it, tell him he has a fiduciary duty to you, and it appears that in this case there was no writ under the Great Seal of the Chancellor. Yet the man's in prison. I wish you to investigate. Yet this case is going on. I wish you to investigate. Or, what is my lawful remedy for this? Because when you go to them under their oath and they have a fiduciary duty to you, they have to answer your questions with truthful answers. But you have to ask pointed questions, a question that can only have one answer to it. Or close to it. Anyways, that's kind of my idea, but let's move on. So anyways, they're talking about a writ of certoria up here where this certis de causis is. And to enroll means to register, to enter in the rolls of Chancery. So they may be enrolled, right? But they're not granted of matters determinable at the common law. So then they wouldn't be enrolled. You won't find one. So you would not find one for your case because if it's a matter determinable at the common law. It is enacted to endure until the next Parliament, that the exception how that the party hath sufficient remedy at the common law, shall discharge any matters in Chancery. So, if you don't find this original writ, again, if you don't find the writ, shall discharge any matters in Chancery, because they had a remedy in common law. The party has sufficient remedy at the common law. So find the document he did at common law, proof that he had a remedy in common law. Again, it sounds like there's three courts that are ongoing all the time. You have the court of record, and the exchequer, and the common pleas. These three courts going on. The court of record, or the King's Bench, let's just call it the King's Bench, make it easier. The King's Bench and the exchequer have concurrent jurisdiction in any civil matter. Any civil matter can be appealed to the King's Bench. And before there can be equity, it has to be lawful, because equity follows the law. First it must be lawful, then if the remedy isn't in law, then you go to equity to get your remedy. But first it has to be lawful. It's just they don't have a remedy. So, going on, no man to be called by privy seal, that's the seal of the court of record, or subpoena to answer any matters but such that have no remedy by the common law. And that to appear so by the testimony of two justices of either bench, and the adventure between them and the plaintiff, which the plaintiff shall always appear in proper person, and find surety by recognizance to prosecute the effective matter of the bill only. And I think they're talking about an English bill, and actually what I think they're talking about is a statute staple, statute merchant. I haven't had a chance to get in that deep, but I plan on it. So whatever the English bill is, I think they're talking about, because you can talk about an English bill a little bit later. And to answer damages if the same fall out against the plaintiff. So basically, he's got to go put up surety that if he doesn't win this bet, he's paying the bet off. The bet's being placed. It's just a casino. For a perpetual law, and the true jurisdiction of this court is enacted in these words. Now again, this is the Court of Chancery, and I believe they're talking about the equity side, but let's read on. For as much as diverse persons have before this time been greatly grieved by writs of subpoena purchased for matters determinable by the common law of his land, to the great damage of such persons so vexed, they're talking about you, and subversion and impediment of the common law foresaid, there's a remedy in common law, why are you taking me to this other court? Our sovereign lord the king will, that the statutes thereof made shall be kept after the form and effect of the same. And no writ or subpoena will be granted from henceforth till surety be found to satisfy the party so grieved and vexed for his damages and expenses, if so be the matter may not be made good, which is contained in the bill. So again, if the plaintiff brings this and he loses, you should win. There should be something for the defendant. You didn't do anything wrong. The man brought an unlawful charge against you. They may do something about that. There is a provision of these words, provided that no matter determinable by the law of this realm shall be said act determined in any form then after the course of the same law, and the king's courts having determination of the same law. So if there's a remedy in the common law, that is the only place you can get it. You can't take it to another court if there is a remedy in the common law. And one of the things that they try, if you remember from the last part 2, is a trespass. They fill out something under a trespass for common law, but it doesn't have a specific damages on there. So all three courts have a piece of paper going to them at the same time. You have one in equity, you have one in common law, and you have one in civil law. They're all going on at the same time. It's one case with 3 different courts hearing it. So never discover to the extraordinary, but it falls short of the ordinary. So it doesn't go to the extraordinary where it falls short of the ordinary. Extraordinary is the exchequer, ordinary is the civil. Whereas matters of fact, by common law, triable by jury of 12 men, this court should draw the matter, examination to another, that is, to judge upon deposition of witnesses, which should be but evidence to a jury in actions real, personal, or mixed. So that would just be evidence to a jury, right? So this court of equity proceeding by English bill is no court of record. If it's a court of record, common law, you're going to have a jury of 12 men sitting there. If there's not 12 men sitting there, you're not in a jury by common law. You're not under common law, you're under an inferior form of law. But if what they're charging you for, which is actually, multiple things, had a remedy in common law, and we find a piece of paper they filled out to make this happen using common law, then their ass is in a ringer. But this particular court of equity is by English bill, and again, I think that's statute staple, statute merchant. That's the statute they're charging you for in a civil case, and they say, "Do you understand the charges?" It's the charges back there in the back room on the statute staple, statute merchant, which are securities of which you've apparently already acknowledged owing. And I think the whole gig is that they're betting that they can get you to acknowledge those before you catch on to what's going on. That's what they need your signature for, and they need you to witness against yourself and all these things for that charge they put in to stand. But you haven't acknowledged it yet. They may have a problem with that when you understand that. This court of equity proceeding, okay, this court of equity proceeding by English bills and therefore can only bind the person only, and neither the state of the defendant's lands nor property of his goods and chattels. So there was a Lord Chancellor. He imposed a fine on a gentleman, sir, a knight, for not performing his decree in Chancery concerning lands of inheritance. So I got to figure out what not performing his decree in Chancery means. Not performing his decree. Because there's something that we need to do in Chancery to get out of the system. We need to get an original writ sued out under the Chancellor, out of him as the exchequer. And estrede the same into the exchequer. Estrede, the term used to signify a true copy or note of some original writing or record. And upon process, the party appearing pleaded that the fine was imposed by the Lord Chancellor for not performance of his decree, that he had no power to assess the same. Okay, for not performing his decree, lands and estrede the same into the exchequer, and upon process, the party appearing, pleading. So I think they're talking about the knight put a true copy or note of some original writing or on the record with the exchequer. Now, that could be your certified copy of record of birth, as far as I know, that shows that it's your property. So, and then upon the process, now this would be in the court of exchequer, the party appearing pleaded. So now he's gone, the sir has gone from being the defendant to the plaintiff, basically, that the fine was imposed by the Lord Chancellor for not performance of his decree, and that he had no power to assess the same. So, because we're talking about inheritances here, they're talking about land, and since it's land, that's the law of the land is the common law. It should have been handled in common law. What's it doing over here? He has no jurisdiction, basically. So the Attorney General, who in my opinion is the elected prosecutor of your county, is the King's Attorney General for that county. Every county is its own kingdom, and there's kings that live there. If you want to be one, you can. The Attorney General confessed the plea to be true and asked the court's advisement concerning the power of the Chancellor in this case. So he's asking the King's bench concerning the power of the Chancellor in this case. And upon debate of the question in court and good advice taken, it was adjudged the Lord Chancellor had no power to assess such a fine. For then by mean he might bind the interest in the land where he had no power, but of the person only. And thereupon the said Sir Thomas was discharged of the fine. So I think the guy took his complaint to the Attorney General. and said, hey man, look what they're doing to me. I accept your oath. I bind you to it. I remind you that you have a fiduciary duty to me, and I demand you not be a concealer, as I wouldn't want to have to take you to the court of inquiry. And show them your evidence. You know, and we'll get better at that. But really, that's the guy we should be taking this stuff to. Okay, so to impose a fine, well, what is a fine? In a conveyance, an amicable composition or agreement of a suit, either actual or fictitious, by leave of the court, by which the lands in question become or are acknowledged to be the right of one of the parties. So he imposed a fine, you know, saying that, hey, I'm saying your stuff is mine, and the guy rebutted it. So fines levied are four kinds. French call or a fine upon acknowledgement of a right of the cognizee to that which the gift of the cognizor. So again, he calls it a fine. They were calling it an English bill earlier. I'm going to assume it's the same thing, which means it's a statute, staple, statute, merchant. I don't know, but an acknowledgement of right of the cognizee at which he has of gift of the cognizor. They're trying to get us to grant them our property on these bonds. And that's what they need your signature for. Although it's not going to be your signature, it'll be your seal. They don't really care about your signature. They want your seal. Everything in common law has to be done under seal. It doesn't need to be done under signature. At the end of the day, it all has to be lawful. However they do it has to be lawful, unless, however, you always have the chance to appeal. All civil cases can be appealed to the appeals court of the King's Bench. And it's not the appeals court that says appeals court. It's going to be tied to the King's Bench. The Court of Inquiry is tied to the King's Bench, and we know now that's the probate court in Michigan. They said so. Someone needs to ask them, well, are you also the appeals court? Or better yet, go ask the guy who's supposed to do this stuff for us, the prosecutor who was elected to the office of the county. Afterward, the said Lord decreed against Waller. So the Chancellor isn't done yet, right? And for non-performance of the decree, imposed a fine upon him on a process. Now, this time he didn't do it in Chancery. You know, before he was in Chancery. This time he's doing it out of Chancery. Well, if it's not in Chancery, I think that he's talking about under common law, because we're talking about this lands, extended the lands. Lands are always common law by Waller in the mid, and that's Middlesex. That was a kind of a writ that was in the last section also, whereupon Waller brought his assize in the court of common pleas, and where the opinions of the whole agreed in every respect with the court of exchequer. Chancellor is also the exchequer. So what the hell does all that mean? We need to go back and see what this Bill of Middlesex does when it's put into play. It's just one of their cards. They don't have many cards, right? And they have to be played in a certain order. And every time they put one down, then they've chosen that path they have to go down. And it has an A and a B. Well, eventually you can shut off all the A's and B's on everything, and it makes their logic fall apart. I just don't know it well enough in my head to explain it. I would have to get the other chapters out, look at them again, look at this. Again, I'm learning it too, so I'm just pointing out what it says. That now this time he's not in Chancery, and he's doing it under this certain kind of writ that we've already talked about. And Waller, the guy who was the defendant, he brought in his assize, and an assize, at least I think that's what it's spelled. I got to go back and look. I may have spelled the word wrong. I was trying to cut and paste. That may not be right. There was an assize of novel dissension, and it talks about that in other parts of Coke's, was an action to recover lands of which a plaintiff had been deceased. So now he's the plaintiff going in. He's going to the court of common pleas, where the opinion of the whole court agreed with the court of the exchequer. I don't really understand this part yet, so I'm going to leave that one alone for now and just move on. The Lord Chancellor or the Lord Keeper is sole judge both in this court of equity and the court concerning the common law. But in cases of weight and difficulty, he doth assist himself some of the judges of the realm. And no greater exception can be taken hereunto than the case of the Lord Steward of England, being the sole judge in trial of nobility, who also is assisted with some of the judges. Yeah, I just point that out because Lord Steward is, he's just now showing up for the first time that I've seen here. So we had been talking about chief justices and exchequer and the chancellor, and now we got the Lord Steward involved. No greater exception be taken hereunto in the cases of Lord Steward of England, being sole judge in trial of the nobility. Well, you're the nobility, right? You're a prince going to be a king, or a princess going to be a queen. You are the nobility that's being charged. And then, what the position of high steward is. It's usually vacant except during coronations and during trials of peers in the House of Lords. So we don't know what the House of Lords is for us. We have an idea what it is in England. If we're landlords, right, the House of Lords to us, to me, is the county building. That's where all your officers are to go do your work. And that's where this trial's happening. In general, but not invariably, the Lord Chancellor was appointed to act as Lord High Steward. So now the Lord Chancellor also is the High Steward. The trial of peers by their peers in the House of Lords was abolished in 1948, although trials on impeachment have been abolished, though not long obsolete. There was a court of Lord High Steward which served the purpose when Parliament was not in session. Okay. So there was a court of Lord High Steward which served this purpose when Parliament was not in session. Well, I don't know if Parliament's ever in session, right? There aren't any living men over there. So there must be a court of Lord High Steward right now. For this court of equity, the ancient rule is good. 3 things are to be judged in courts of conscience. So he's saying that the courts of equity are the courts of conscience. That's cove accident, breach of confidence. Court of equity is a court of conscience. Since equity follows the law, it has to be lawful first. So okay, there are 3 things that are to be judged in the court of conscience. Coven. Well, what's coven? All covens, frauds, deceits for which there is no remedy by ordinary course of law. Well, that's what common law is, man. That's the kind of stuff it takes care of, right? Those are all lawful criminal acts. So that's taken away. In general, courts of equity will relieve a party who cannot attain justice in consequence of an accident, which will justify the interposition of the court of equity. This jurisdiction, being concurrent, will be maintained only, first, when the court of law cannot grant suitable relief, and secondly, when the party has conscientious title to relief. Okay, so if they have, and secondly, when the party has conscientious title to relief. I need to look at that. Many actions are redressed in a court of law. So many actions are redressed in a court of law, which means they wouldn't be in a court of equity. Again, if there's a remedy in common law, you're not supposed to be doing these other things, yet they appear to be doing them. And many cannot be redressed even in the court of equity. So, okay, I'm going to pause for a minute and go to my next piece of paper. Hang on a second. Okay, continuing on. My, isn't this fun? We're going to look at Book 3, Chapter 19 of Process. From a book of authority, brought into court is the law. Let's again see what Mr. Blackstone, let's see what Bill has to say. The next step for carrying on a suit, after suing out the original, now the original again, under the Great Seal from the Chancellor, is called the process, being the means compelling the defendant to appear at the court. This sometimes called original process has been found upon original writ. Go figure. And also is distinguished from an intermediate process. So we got an original process, and we may have a thing called a mensi or immediate intermediate process, which issues pending the suit upon some collateral interlocutory matter, such as to summon juries, witnesses, and the like. Intermediate process is also sometimes put in contradiction of final process or process of execution. Okay? Contradiction. I guess it means different, but I'll have to go look it up. And then it signifies all such process as intervenes between the beginning and the end. Is also sometimes put in contradiction to final process or process of execution. And then it signifies all such process as intervenes between the beginning and the end of the suit. So if they're doing a mens or intermediate process, they're saying that covers everything. Okay? But process, as we are now to consider it, is the method taken by the law to compel compliance with the original writ, of which the primary step is by giving the party notice to obey it. This notice is given upon all real we command writs, and upon all personal writs for injuries in courts at the return of the original writs, and whereupon all personal writs for injuries in court at return of the original writs given to the defendant by 2 sheriff's messengers called summons. Okay, so if you got summons, either in person or left at his house or land, in like manner as in civil law, the first process is by personal citation. So we're not talking civil law. This is what's happening in the law side, the common law side. This warning on the land is given in real actions by erecting a white stick or wand on the defendant's ground. They ever come put a white stick in your yard? Which stick or wand amongst the northern nations is called the message staff, and by this statute must also be proclaimed on some Sunday before the door of the parish church. So, sounds like they got to call it out in front of the church, right? They have the original writ given to the defendants. So an original writ has to be given to you by 2 sheriff's messengers called summoners, either in person or left at his house or land. In a like manner as in civil law, the first process of the personal citation. The warning on land is given in real actions. Did they come put a white stick or wand in your yard? If they didn't, it wasn't done lawfully. By the way, go look up the word oyez, O-Y-E-Z. Oyez, oyez, oyez is the beginning of every court of law before the proclamation starts. And if you ever watched Return to Oz, Dorothy is putting her hands on things and saying Oz. I don't know if Oz is just oyez, but she does it 3 times and the straw man comes to life. Go figure. If the defendant disobeys this verbal monition, the next process by writ of attachment, or pone. Pone is an original writ issuing out of Chancery for the purpose of removing a plaint from an inferior court into a superior court at Westminster, from civil to equity. Okay, so if the defendant disobeys the verbal motion, the next process by writ of attachment. But again, this is if they've done the original one, right? Because we're under the original. Yeah, we're doing everything by common law here. So we got a white stick in our ground, and we didn't pay any attention to it. Well, then they're supposed to do this other writ. This is writ not issuing out of Chancery, but out of the Court of Common Pleas, being grounded on non-appearance of the defendant at the return of the original writ. Okay, so this has something to do with what was earlier in the part above. Now I know where to go try to tie them together. And thereby the sheriff is commanded to attach him and take engage, that is, certain of his goods, which he shall forfeit if he does not appear, or by making him find safe pledges or sureties, who shall immersed in the case of his non-appearance. So they have to have the original first then they get this one. This one's going to come out of the Court of Common Pleas. Now, I don't know what seal that's going to have on it. That would be interesting. And by the way, the sheriff's got 2 courts himself. Everybody's a court. This is also the first immediate process. This is also the first and immediate process without any previous summons upon actions of trespass or other injuries, which, though not forcible, are yet trespasses against the peace as deceit and conspiracy. Where the violence of the wrong requires a more speedy remedy, and therefore the original writ commands the defendant to be at once attached without any precedent warning. Okay? If after attachment the defendant neglects to appear, he is not only forfeits his security, but is moreover to be farther compelled by writ, another writ, or distress or something, which is subsequent process issuing from the Court of Common Pleas, commanding the sheriff to distrain the defendant from time to time and continually afterwards, by taking his goods and profits of his lands, which he forfeits to the king if he does not appear. Now, the Court of Common Pleas is just the civil court. So, but what seal are they putting on that paperwork that comes out of the civil court? Do they have their own? Or are they using the Court of Records seal? In like manner as in civil law, if the defendant absconds so that a citation is of no effect, his adversary is put in possession of his goods. And hereby the common as well as civil law, the process ended in case of injuries without force, the defendant, if he had any substance, being gradually stripped of it, all by repeated distresses. Sounds like a garnishment to me, till he has rendered obedience to the king's writ. And if he had no substance, the law held him incapable of making satisfaction, and therefore looked upon all further process as a nugatory. So they're just going to keep taking your stuff. And besides, upon feudal principles, the person of the fiduciary was not liable to be attached for injuries merely civil, lest thereby his lord should be deprived of his personal services. But in case of injury accompanied with force, the law, to punish the breach of the peace and prevent the disturbances for the future, provided also a process against the defendant's person, in case he neglected to appear upon the former process of attachment, and had no substance whereby to be attached, subjecting his body to imprisonment. You can't pay, you're going to jail. But only injuries accompanied with force. Breach of the peace, to prevent disturbance. So if they can get you for a breach of the peace, then they can take your body to jail. Right? Because if right now we have no substance, even living it as a subject, you have no substance, man. You gave it away, right? But if you breach the peace, they can take your body to jail. But this immunity of the defendant's person in cases of peaceable though fraudulent injuries, producing great contempt of law and indigent wrongdoers, a taking was also allowed. They're going to find another way to take you, to arrest the person in actions of account, though no breach of the peace was suggested by the statutes in actions of debt. So they found a way around that by doing this. You think that's bad? Well, there may be some answers to it here. Before which last statute, a practice had been introduced of commencing the suit by bringing the original writ of trespass, why he had broken his close, for breaking the plaintiff's close. Oh, I had close somewhere. Which by old common law subjected the defendant's person to be arrested by writ of that you take, and that afterwards by connivance of the court, the plaintiff might proceed to prosecute any other less forcible injury. A close signifies interest in the soil. A connivance, an agreement or consent indirectly given that something unlawful shall be done by another. So they're going to sue out this writ of trespass, and we're going to find it has no value because they want to charge you with something else. And if they can get away with it, then you've got to pay the rest. This practice, though a custom rather than necessity, and for the saving of some trouble and expense in suing out special original adapted to the particular injury, still continues in almost all cases, except in actions of debt, though now, by virtue of statute, above cited, might have happened upon almost every species of complaint. So, they said except in actions of debt, except though now, by another statute, and others, the taking might have happened upon almost every species of complaint. So I guess they're saying they can do it for debt now. If, therefore, the defendant being summoned or attached makes default and neglects to appear, or if the sheriff returns nothing, or if the sheriff returns nothing, they have to return these writs. So if the sheriff returns nothing, or that the defendant has nothing whereby he may be summoned, attached, or restrained for the taking, now usually issues being a writ commanding the sheriff to take the body of the defendant if he may be found in his bailiwick or county, and him safely to keep, so that he may have him in court on the day of return to answer the plaintiff a plea of debt or trespass, etc., as the case may be, because now it says they're doing debt, so they were able to work debt into it. This writ and all others subsequent to the original writ not issuing out of Chancery. This writ and all subsequent to the original writ. So only the original writ's coming out of Chancery, it sounds like. So this one is not. But from the court into which the original was returnable, and being grounded on what has passed in the court in consequence of the sheriff's return, are called judicial, not original. Okay. On what has passed in court in consequence to the sheriff's return. Well, what if he returned nothing? So these are judicial writs. They're not originals. That's how you can tell the difference. They issue under the private seal of the court, under the privy seal, and not under the great seal of England, and are not in the king's name, but in the name of the chief justice only. And these several writs, being grounded upon the sheriff's return, must respectively bear the date, the same day of the writ immediately preceding was returnable. Okay, and these several writs, being grounded on sheriff's return, so they have to do with his return, must respectively bear the date, the same day on which the writ immediately preceding was returnable. So if you know when a writ was returnable, then the next writ is supposed to sue out on the same day. If it doesn't, it wasn't done lawfully. Okay, return of writs. A short accounting in writing made by the sheriff or other ministerial officer of the manner in which it has been in which he has executed a writ. It is the duty of such officer to return all writs on the return day. On his neglecting to do so, a rule may be obtained on him to return the writ, and if he do not obey the rule, he may be attached for contempt. Did they return the writ? And a writ can be a warrant, in my opinion, because it's a writ quo warranto. Well, that's got to be warrant. This is the regular and orderly method of process, but it is now usual in practice to sue out a taking in the first instance upon a supposed return of the sheriff. So they're going to suppose he returned it. And again, they said he may not have, but let's suppose he did, especially if it is suspected that the defendant upon notice of the action will abscond, and afterwards a fictitious original is drawn up, with proper return thereupon, in order to give the proceedings a color of regularity. So there'll be something fictitious about the piece of paper. I don't know exactly what that is yet, but they're just telling us that if it's done one way, that it's supposed to follow this line with the sheriff bringing it in, returning it, soon out the next one the same day, doing it, bringing it back on the return date, getting another one, going out. However, they may just skip all that and go to this taking upon a supposed return of the sheriff. And then they fill out the paperwork later, fictitiously. Well, I would say that's fraud. I might be taking that to the King's Attorney General, ask him, hey, check on this, would you? I think this might have happened. Because it doesn't matter what you ask them to inquire on. When a court of inquiry is open, it's just to go and asks questions. It's inquiring. But anything it finds is fair game, whether it had to do with that particular issue or not. It doesn't matter. They really don't want the Court of Inquiry digging in their drawers. So when this taking is delivered to the sheriff, and he, by his undersheriff, so the undersheriff grants a warrant to his inferior officers or bailiffs to execute it on the defendant. And if the sheriff is somewhere in which county the injury is supposed to have committed and action is laid, cannot find the defendant in his jurisdiction, he returns that he is not found in his bailiwick. Thereupon another writ issued called another one directed at the sheriff of the county where the defendant is supposed to reside, reciting the former writ, and that it is testified, it is witnessed. Well, okay, would they witness? It better have a witness statement on it, reciting the former writ, and that it is testified. So it has to have the words of the former writ and then be sworn to by somebody. If it isn't sworn, if they don't have it under seal, testified, it ain't got no value. It's not completed. And that the defendant lurks or wanders in his bailiwick, whereupon his command to take him in a former, as in the former taking. But here also, when the action is brought in one county and the defendant lives in another, it is usual for saving trouble, time, and expense to make out. But here also, when the action is brought in one county and the defendant lives in another, it is usual for saving trouble, time, and expense to make out another writ, another taking, at the first, supposing not only an original but also a former taking to have been granted, which in fact never was. So he's saying this is how they do it now. But here also, when the action is brought in one county and the defendant lives in another, it is usual for saving trouble, time, and expense to make out another kind of taking at the first, supposing not only the original writ, but also the former writ to have been granted, which in fact never was. So the way this is written, they're saying that this one up here never was either. This other supposed writ. And the whole reason is there was no original. And this fiction, being beneficial to all parties, is readily acquiesced and has now become the settled practice. Oh, okay. And this fiction, being beneficial to all parties, is readily acquiesced. So we can get somebody acquiesced to it. Being one among the many instances to illustrate the maximum law, legal fictions are founded in equity. I should have looked up founded. But where the defendant absconds and the plaintiff would proceed to an outlawry against him, the original writ must then be sued out regularly, and after the taking, and after that a taking. And if the sheriff cannot find the defendant upon the first writ, returns, he is not found, then issues another writ for an alias, and after the pleas to the same as the former, only after the words, we command you, this clause is inserted, as we have seen, as we have formerly, or as we have often commanded you. So if they want to call you an outlaw, it has to be a we command writ. Right? And the we command writ is the only one that has any power. And if this one's returned upon all of them, then a writ of extingent or because to cause to be required may be sued out, which requires the sheriff to cause the defendant to be proclaimed required or exacted in 5 county courts successively to render himself, and if he does, then to take him in as in then taking, but if he does not appear and is returned that required 5 times, he shall then be outlawed by coroners of the county. Okay, that now the coroners of the county, they work in the King's Bench. The head coroner is the Chief Justice of the King's Bench, and him and three other guys make up the sovereign coroners of the county. Okay, dwells make these. Okay. Shall issue the same extension commanding the sheriff of the county wherein the defendant dwells to make 3 proclamations, therefore in places the most notorious and most likely to come to his knowledge, a month before the outlawry shall take place. Such outlawry is putting a man out of the protection of law, so that he is incapable to bring an action or redress of injuries, and it is also intended within the forfeiture of all one's goods and chattels to the king. And therefore, till some time after the conquest, no man could be outlawed but by felony. But in Bracton's time, and somewhat earlier process of outlawry was ordained to lie in all actions of trespasses. And they're going to fill out this piece of paper for a trespass on you that's going to allow this other stuff to happen. But it can all be taken apart. And since by the variety of statutes, process of outlawry does lie in diverse actions that are merely civil, provided they are commenced by original and not by bill. All right? So they can do an outlawry under civil, provided it's under an original, under the Great Seal, and not by the bill. If after outlawry the defendant appears publicly, he may be arrested by writ of take the outlaw, committed to till the outlawry be reversed, which reversal may be had by the defendant appearing personally in court and in the king's bench without any personal appearance, so that he appears by attorney. Okay, again, appears by attorney. Well, what attorney? The prosecutor, the guy who was elected to be the attorney for the people of the county. And any plausible cause, however slight, will in general be sufficient to reverse it, it being considered only a process to compel an appearance. All this just to get you in the courtroom. But then the defendant must pay full cost and put the plaintiff in the same condition as if he had appeared before the writ to be exacted from what is due was awarded. Such is the process in the Court of Common Pleas. So now they have to pay it, be extracted from what's due was awarded. And I believe that there's no jury trial in a civil court. The max is worth 40 shillings. Such is the first process in the Court of Common Pleas. In the King's Bench, they may also, and frequently do, proceed in certain causes, particularly in actions of ejectment, trespass by original writ, with attachment and taking thereon, returnable not at Westminster, where the common pleas are fixed in consequence of the Magna Carta, but the King's Bench being removable to any part of England at the pleasure and discretion of the Crown. So, listen, this is going to get too long. I'm going to stop here and just do another video. I think that's probably the best way to do it. And we'll pick up here. All right. See ya.